Start. In the judgment of the two cross criminal applications between the identical parties Haji Sheikh Hussain Abdul Jabbar and six other versus State of Maharashtra through police station Lakadganj Nagpur and Muhammad Hanif Abdul Rashid delivered on November 4, 2025 at the Nagpur bench of the Bombay High Court. Justice Urmila Joshi Phadke and Justice Nandesh S. Deshpande, the author of the judgment, have in view of the law laid down by the Supreme Court very clearly stated that the power under Section 482 of the Criminal Procedure Code is not to be exercised to stifle a legitimate prosecution only on the basis of a settlement between the parties. Para. Tosif Ahmed, the applicant to in the criminal application number 1207 of 2025, is the non-applicant in the criminal application number 1203 of 2025 and is the complainant. Likewise, the applicant 5 in 1203 of 2025, Muhammad Hanif Abdul Rashid, is the non-applicant number 2 in the criminal application number 1207 of 2025, though the application 1207 of 2025 quashing of the FIR number 213 of 2015 lodged against the applicant by the non-applicant number 2 was sought against the applicant at the behest of the non-applicant number 2 for the offences punishable under sections 307, 143, 147, 148, 149 and 452 of IPC. Facts are similar regarding the criminal application number 1203 of 2025, excepting that there is section 452 IPC is not there. Additionally, sections 4 and 5 of the Arms Act are there. In both the applications, the applicants had unsuccessfully sought quashing of respective FIRs and charge sheets. Para. As was observed by the court in the decision State of Maharashtra versus Vikram Anantara Doshi 2014-15 SCC 29. The court's principal duty while exercising powers under section 482 of CRPC to quash the criminal proceedings should be to scan entire fact to find out the thrust of the allegations and the crux of the settlement. Para. Furthermore, by relying upon the judgments of Gyan Singh and Narinder Singh and others versus State of Punjab 2014 on line 265, this court has observed that when it comes to a question of compounding an offence under section 307, 294 and 34 of the IPC, by no stretch of imagination it can be held to be an offence as between the private parties simpliciter. Such offences will have a serious impact on society at large. The accused are facing trial under section 307 as the offences are definitely against society and the accused will have to necessarily face trial, come out unscathed by demonstrating their innocence. The same view has been reiterated in the State of Madhya Pradesh versus Deepak 2014 10 SCC 285 and State of Madhya Pradesh versus Manish 2015 8 SCC 307. Para. Thus, the common thread emerges from perusal of these judgments that the High Court should be slow enough to quash the FIR and the charge sheet only on the basis of the settlement for the offences punishable under 307 of the IPC and the Arms Act, that such power is not to be exercised in those prosecutions which involve heinous and serious offences like murder, rape, dacoity, as such offences are not private in nature and have a serious impact on society. Para. The FIR number 213 of 2015 and the corresponding charge sheet invoke offense under section 307, 143, 147, 148, 149, 552 of the IPC, read with sections 4 and 25 of the Arms Act. In the indoor inquiry certificate, assault with head injury is shown. A knife is recovered from the applicant number 4. A sword was recovered from applicant 3. A iron rod was recovered from the applicant 7. A cookery was also recovered from the shop. All these weapons and clothes have blood stains over them. The injury report clearly states that these injuries are possible with some of these weapons. This report also shows a head injury in the report of non-applicant number 2 in the application number 1203 of 2025. There is specific reference of use of sword and injuries were caused due to it. Even the statements of witnesses speak about the use of sword. Para. Moreover, the trial court has recorded in its judgment on June 27, 2017, that at the threshold stage the police could not have concluded regarding the aspect of provocation, which is an element to be dealt in the course of evidence and trial. So also the police could not have made their opinion in view of the cross report filed by accused against the informant and others. Both the reports and cases are different, and the material of one case could not have been considered in another case. The report and statement clearly spell out that victim has been wounded on his head with a sword, and so also informant saved himself from the ghastly attack of sword on his neck. It could be also read from the report that the accused were armed, and one of them, Abdul Hanif, accused number 12, exhorted others accused to kill the informant and others. The vital aspect for an offense under section 307 IPC is the intention and not the nature of injury. Perhaps there may not be any injury, still having an intention to kill would make out a case under section 307. Viewed from this angle, the opinion of medical officer cannot be given much weight at this juncture of the case. Para. In evaluation, the High Court is of the view that prima facie case under sections 143, 147, 148, 307, read with sections 4 and 25 of the Arms Act has been made out co-accused. Hence, accused needs to be summoned to answer the charge and face the trial for the offences under sections 143, 147, 148, 307, read with section 349 IPC and sections 4 and 25 of the Arms Act. The administrative office of the trial court was directed to register this case in the nature of warrant trial. Para. In this case, dangerous weapons have been found and recovered from the accused persons in both cases. there is evidence of use of these weapons by the accused persons. Their clothes have been found with blood stains. In view of this, the High Court's considered view is that only because of settlement between the parties it would not be proper to quash the first information report and the consequent charge sheet. The judgments in the case of Narinder Singh and Nausha Ali even speak of the offences under section 307 would fall in heinous and serious offence. It is true that only offence under 307 IPC is invoked in the matter, but that would not deter this court from exercising jurisdiction. However, looking to the fact that dangerous weapons have been seized from the accused persons, it would not be a proper case to exercise inherent jurisdiction under the section 482 of the CRPC, and in view of this, the High Court here has rejected both the applications.